started. Once again, my name is Anna Limoges. I'm president of the Second Circuit Women in Law. We also have Emily Maurice on. She is the vice president. I do not know if Lindsay, let me see if Lindsay's on. And Lindsay Janklow is not on, but she is our treasurer. I want to say thank you to all of you who are participating today. We open this up to non-members considering the topic and our speaker, Judge Schreier. And we would like to make sure that everybody knows that the importance that Justice Ruth Bader Ginsburg had on our lives and our careers. She, as everybody knows, died September 18th and was an Associate Justice of the United States Supreme Court from 1993 until her death. With that, I'm going to hand it over to Judge Schreier. And once again, thank you, Judge, for reaching out to me and telling me you wanted to talk about this.
Thank you for inviting me here this afternoon. And I first of all wanted to thank Hannah Moravec. She's one of my law clerks, and there will be just a few slides that are presented during this. She's operating the slides for me and put them together. As you all know, Associate Justice Ruth Bader Ginsburg passed away on September 18th of 2020. It's important for us to take a moment to think about her legacy, and I wanted to share with you a few interactions that I had with her over the years. Shortly after I was confirmed to be a federal district court judge, Craig Gaumer, who was an assistant U.S. attorney in the U.S. Attorney's Office at the time, wrote to Justice Ginsburg and told her that I was the first woman to be confirmed as a federal district court judge in South Dakota. And he asked her if she would send me a congratulations note, which she did. And I was so thrilled to receive a letter from a Supreme Court justice and really quite surprised that she'd take the time to do something so incredibly meaningful for a new district court judge. The following year, I went to phase 2 of what we call Baby Judges School in Washington, D.C. And as part of the training, the new district court judges are invited to attend a dinner at the Supreme Court. Several of the justices attend a reception before the dinner and stay through the dinner. And I was so thrilled to finally have the opportunity to meet Justice Ginsburg in person and to express my sincere thanks for the congratulatory letter that she had sent me. We had a nice but short chat about being a judge. And I can remember that as I stood next to her, I felt like an elephant because she was just so tiny. And then we joined a larger group for a photo. And you can see here, she's in the front row along with Justice O'Connor and several other of the Supreme Court justices, and I'm in the very last row on the far left-hand side. The next time I met Justice Ginsburg was when I served as the chief judge for the District of South Dakota. One of my friends at the time was the chief judge in Guam, and she was really good friends with Justice Sotomayor. So after Justice Sotomayor was confirmed, my friend contacted Justice Sotomayor and asked if she would have a meeting with just the female chief judges during our upcoming National Chief Judges meeting. And Justice Sotomayor agreed to do so and invited us to a private tea at a reception room in the Supreme Court. There were about 15 to 20 female chief judges at the time, but then the day before the event, Justice Sotomayor had to cancel because of the death of a close friend of hers. So she asked Justice Ginsburg to fill in, and Justice Ginsburg agreed. So we were able to meet with Justice Ginsburg in a small reception room. And I remember she talked to each of us individually first, and then she made remarks to the group as a whole. She told us about her struggles as a young lawyer, her struggle to get her first job, her appearances before the Supreme Court as an advocate and a lawyer, the work that she did on behalf of women, and she ended by saying that she was so proud to be with a group of women who were now chief judges in their districts. It was really an incredible experience to hear about her struggle firsthand with such a small, intimate group of other women, all who had their own stories about hurdles that they passed in order to climb over and become federal district court judges. In 2014, I became the 8th Circuit District Court representative on the Judicial Conference. The Judicial Conference is led by the Chief Justice, and it's made up of the Chief Judge of each circuit and one district court judge representative from each circuit. In the 8th Circuit, the representative is elected by all of the other judges, their peers, and I'm the first woman to have been elected as the district court representative for the 8th Circuit. The Judicial Conference meets twice a year in person in the Supreme Court, and we all sit around a huge, large table in the Supreme Court building. The Chief Justice runs the meeting. We hear reports from the Senate and the House Judicial Committee chairs and ranking members and the Attorney General of the United States. And the evening after the meeting, a reception is held in the Supreme Court. All of the justices are invited. Some attend and some never attend. Justice Ginsburg attended almost every reception. 2 years ago, I talked to her about the fact that she was coming to Omaha to attend the 8th Circuit Judicial Conference. It was supposed to be this past summer. She had agreed to attend and to discuss and celebrate the 100-year anniversary of the passage of the 19th Amendment, where women were granted the right to vote. Not only was she going to answer questions that were posed to her by Judge Lori Smithcamp and Judge Jane Kelly, but she also agreed to appear on a panel to discuss the Frontiero case that she'd argued before the Supreme Court in 1973. She told me she was really looking forward to the discussion, and especially the reunion during the conference with others who had worked on the Frontiero case and Ms. Frontiero herself. Even though Justice Ginsburg had recently announced that she was fighting a new bout of cancer, she remained committed to attending the conference. And then even when COVID set in, she still planned to attend virtually. And I know that had the conference happened, she would have made her remarks one way or another. In 2018, the Federal Judges Association had its quadrennial meeting in Washington, D.C. As part of the program, Justice Ginsburg was the highlight of the conference. She answered questions posed to her by her two biographers, Mary Hartnett and Wendy Williams. And Judge Lang and I were both there and were seated less than 25 feet away from her. And here's a couple of photos that I took during the conference while she spoke. It was an incredible opportunity to hear about her life, her law career, and the highlights of her time on the bench. Last year, I celebrated my 20th year anniversary as a district court judge. And as part of the celebration, my law clerks, Claire Wilka, Elena Holmstrom, Kelly Maxwell, and Hannah Moravec, along with the pro se law clerks, Brooke Schmidt and Mallory Schulte, organized a surprise party. And my sneaky law clerks contacted Justice Ginsburg beforehand and told her that they were throwing this surprise party for my 20th anniversary. They asked if Justice Ginsburg would lend me a jabot to wear during the party. And not only did she send one for me to wear, but she told me to keep it. And here's a picture of it. It meant so much to me when I received it, but it means even more now that she's gone. The jabot really became a symbol of Justice Ginsburg. And I hope this Halloween that I see a lot of little girls out there wearing black robes and jabots. And finally, I wanted to talk about 3 matters that Justice Ginsburg thought were significant. Every time I've heard her speak, she's included these 3 cases in her remarks. While she was in private practice and again while on the court, she had the remarkable ability to see things as they are and as they have been, and to question whether they should remain that way. And these cases are examples of her vision. And I'm sorry for crying. The first case is Frontiero versus Richardson. Sharon Frontiero was a lieutenant in the U.S. Air Force. Her husband, Joseph Frontiero, was a military veteran and a full-time student in college. Under federal law, married members of the military were afforded a supplemental housing allowance and on-base health care for their dependents. but the law defined a dependent more favorably for males than for female service members. If Joe had been the service member and Sharon the student, she would automatically have been treated as Joe's dependent without regard to her income, qualifying the family for the statutory benefits. As a servicewoman, however, Sharon was required to prove that her husband relied on her for more than half of his expenses before her family would be deemed eligible. Sharon paid the majority of the family's expenses, but fell a bit short of the required 1/2 of Joe's support. Sharon filed a lawsuit in federal court against the Secretaries of Defense and the Air Force, as well as her commanding officer, claiming that the federal law's less generous family benefits for female service members violated her constitutional right to equal protection of the laws. When the case reached the Supreme Court, then Professor Ruth Bader Ginsburg, on behalf of the American Civil Liberties Union, wrote a 75-page amicus, also known as a friend of the court brief, in support of Sharon's claim. In it, she laid out the long history of discrimination against women and the Supreme Court's position, which was unwavering until 1971, namely that legal distinction by sex, what she often called sex role pigeonholing, was rational and therefore constitutional. She characterized this as the anything goes standard of review. It authorized legislators to draw, as the Supreme Court summed up in 1848, a sharp line between the sexes. Ginsburg's core contention in the ACLU brief was this: legislative line drawing based on sex should, like race classifications, be labeled suspect. So the court should extend to legal distinctions based on gender the same strict scrutiny the justices in the early 1970s reserved to race-based legal distinctions. The essential feature of strict scrutiny is a requirement that the state justify its suspect classification by proving that it was necessary to a compelling state interest and narrowly tailored to serve that interest. The attorneys for Sharon, who had initially requested the ACLU's assistance with the Supreme Court brief, had declined to make this argument. So Ginsburg and the ACLU submitted the argument in an amicus brief. After a little bit of diplomacy, the ACLU and Sharon's attorney agreed to submit a joint final reply brief where they both argued together that sex was a suspect class. This case was the very first time that Ginsburg made a personal appearance before the Supreme Court. She and Sharon's attorney split the time for oral argument, and Ginsburg presented in person the argument that sex was a suspect class. Professor Ginsburg lost the battle for designating sex as a suspect classification, but won the Frontiero case on a vote of 8-1. Only 4 of the justices, in a plurality opinion by Justice Brennan, agreed with her that gender classifications were worthy of strict scrutiny. But 4 additional justices, although they declined to label sex classifications as suspect, found the statute's gender-specific definition of dependence unconstitutional nevertheless. Later, in a subsequent case, Ginsburg coaxed the justices into articulating an intermediate standard of review for sex discrimination cases, and that remains the standard today. The next case I'd like to discuss is United States versus Virginia. The case was argued before the Supreme Court after Ruth Bader Ginsburg became an associate justice. It concerned a military college, the Virginia Military Institute, also known as VMI. VMI was the sole single-sex school among Virginia's public institutions of higher learning. Since its founding in 1839, VMI had produced civilian and military leaders for the Commonwealth and the nation. The school's unique program and unparalleled record as a leadership training ground led some women to want to seek admission. The United States, on behalf of women capable of all the activities required of VMI cadets, brought this lawsuit in 1990, maintaining that under the Equal Protection Clause of the 14th Amendment to the U.S. Constitution, Virginia may not reserve exclusively to men the educational opportunities that VMI and no other Virginia schools afford. Justice Ginsburg wrote the majority opinion for the court and announced it orally from the bench. She described this announcement as one of the most personally satisfying that she delivered in all of her years on the bench. And this is what she said in part, and I'm quoting her. I wish I could have found a live delivery of her, but I wasn't able to. The lower courts concluded the schools were sufficiently comparable to meet the demand of equal protection. We reversed that determination. Our reasoning centers on the essence of the complaint in the United States and on the facts that are undisputed. Some women, at least, can meet the physical standards that VMI imposes on men, are capable of all the activities required of VMI cadets, prefer VMI's methodology over VWIL's, could be educated using VMI's methodology, and would want to attend VMI if they had the chance. With recruitment, the district court recognized VMI could achieve at least 10% female enrollment, a number the district court said was sufficient to provide female cadets with a positive educational experience. If most women would choose VMI's adversative method, many men too would not want to be educated in VMI's environment. The question before us, however, is not whether women or men should be forced to attend VMI. Rather, the question is whether Virginia can constitutionally deny to women who have the will and capacity, the training and attendant opportunities that VMI uniquely affords, training and opportunities VWIL does not supply. To answer that question, we must have a measuring rod, what lawyers call a standard of review. In a nutshell, that's the standard our precedent establishes. Defenders of sex-based government action must demonstrate an exceedingly persuasive justification for that action. To make that determination, the defender of gender line in the law must show, at least, that the challenge classification serves important governmental objectives and that any discriminatory means employed is substantially related to the achievement of those objectives. The heightened review standard applicable to sex-based classifications does not make sex a prescribed classification, but it does mark as presumptively invalid, incompatible with equal protection, a law or official policy that denies to women, simply because they're women, equal opportunity to aspire, achieve, participate in, and contribute to society based upon what they can do. Under this exacting standard, reliance on overbroad generalizations, typically male or typically female tendencies, estimates about the way most women or men are, will not suffice to deny opportunity to women whose talent and capacity place them outside the average description. As this court said in Mississippi University for Women versus Hogan some 14 years ago, state actors may not close entrance gates based on fixed notions concerning the roles and abilities of males and females. A remedial decree must cure the constitutional violation in this case, the categorical exclusion of women from an extraordinary educational leadership development opportunity that's afforded men. To cure that violation and to afford genuinely equal protection, women seeking and fit for a VMI quality education cannot be offered anything less. We therefore reverse the Fourth Circuit's judgment and remand the case for proceedings consistent with this opinion. And the last case I'd like to discuss is a case where Ruth Bader Ginsburg wrote a dissent. She viewed dissents as important to appealing to the intelligence of a future day or for a call to action from the other political branches of government. An example of this is a dissent she summarized from the bench in 2007 in Ledbetter versus Goodyear Tire and Rubber Company. The plaintiff, Lily Ledbetter, worked as an area manager at a Goodyear tire plant in Alabama. In 1997, she was the only woman that Goodyear employed in such a post. Her starting salary in 1979 was in line with the salaries of the men in her same post, but over time her pay slipped. By the end of 1997, there was a 15 to 40% disparity between her pay and the salaries of the 15 men doing the same work. A federal jury found it more likely than not that Goodyear paid Ledbetter an unequal salary because of her sex. The Supreme Court, in a 5-4 decision, nullified the verdict, finding that she filed her claim too late. The court found that Ledbetter must file claims of discrimination each time Goodyear failed to increase her salary commensurate with the salaries of her male peers. An annual pay decision not contested promptly within 180 days became grandfathered beyond the remedial reach of Title VII. In Justice Ginsburg's dissent, she noted that the majority ignored real-world employment practices that Title VII was meant to govern. Sue early on, the majority counseled, when it's uncertain whether discrimination accounts for the pay disparity you're beginning to experience, and that you may not even know that men are receiving for the same work. But if you sue only when the pay disparity becomes steady and large, your now winnable case is blocked as untimely. Heads, the employer wins. Tails, the employee loses. That situation, she urged, could not be what Congress intended when in Title VII it outlawed discrimination based on race, color, religion, sex, or national origin in our nation's workplaces. The ball is in Congress's court, she wrote, to correct the Supreme Court's parsimonious reading of Title VII. Congress responded within days of the court's decision and passed the Lilly Ledbetter Fair Pay Act. Now Title VII makes it plain that each paycheck to a woman in Ledbetter's situation renews the discrimination and restarts the time within which suit may be brought. These are just 3 examples of the work that Justice Ginsburg committed her life to. She strived to make this a more perfect union, a place that would be better for her children and her grandchildren than what she had experienced. She often said, the greatest menace to freedom is an inert people, and she advised people to fight for the things that you care about, but do it in a way that will lead others to join you. I encourage you to read the book, My Own Words, Ruth Bader Ginsburg. It contains excerpts from Ruth Bader Ginsburg's own writings as a child, an advocate, and as a justice. It reminds you of why you went to law school so that you would have the tools to fight for things that are important for you. When Justice Ginsburg's death was announced, I felt like I'd just been punched in the stomach. It really took my breath away. She'd been through so many battles with cancer and survived all of them. I thought she was just immortal. I had just been talking with a friend earlier that day, another judge, and he told me that she had just spoken a week earlier over a Zoom meeting at a going away party for the Chief Judge of the Second Circuit, Judge Katz. And Judge Katz and I had been confirmed together at the same time. We shared a confirmation hearing. My friend said that Justice Ginsburg looked strong and was well-spoken, so I thought she was in good health, but it was not to be. A few days later, after she had passed, when I saw a photo of her former law clerks lining the steps of the Supreme Court while she laid in state, the tears just flooded down my cheeks. She was a remarkable woman who led a remarkable life. And I challenge you not to let her death just pass as another death. As she would say, we all need to make sure that we are not inert, that we get out there and we fight for the things that are important. And I'd be glad to answer any questions. I'm not a Ruth Bader Ginsburg scholar, but I can try to answer some.
Well, I just have a comment. I had to get a tissue real quick. You really made me tear up.
Me too.
And I do also have one more comment. I see that some of your former clerks are on here. I see, let's see, Claire Wilka is on here, Kelly's on here. I think that is really awesome what they did.
It was really so incredible that they went behind my back, because usually I feel like I know what's going on in the courthouse. But it was a total surprise. They gathered everybody down into the courtroom on the first floor, and then Judge Pearsall and Judge Duffy snuck me down to the floor without me knowing why I was going down there. So I walked into the courtroom. I was just totally shocked that it was filled with people, and then even more surprised when I got the gift from Justice Ginsburg.
Oh, I do see Elena is also on. So, so does anybody have any questions? You can also make some comments if you have any stories or maybe a favorite quote that you know of from RBG. And I know I have something that I just admired so much about Ruth Bader Ginsburg. There's a lot to admire, but was her perseverance. Even though, you know, it was a lifelong struggle for her to push against the walls, she continued on. And I'm sure at times she maybe was tired, but she persevered right through it. And there is a quote on the perseverance, and supposedly it's her. I don't know, but I think it is. Real change, enduring change, happens one step at a time. And I think that can be a great little piece of guidance for many different aspects in our lives, especially today. So anybody else? I'll give like 2 minutes here and see if anybody has a quote that they want to share or comment.
So one of the things that I really admired about her, when she was an advocate, she was able to frame issues and point out arguments in a way that people that weren't in the same shoes as a woman were able to understand and relate to. And I think so many times as lawyers, that's the very best quality that you can have, is to be able to explain your case, especially if you're before a jury. So it's not just a bunch of facts coming in, but it's something that's relatable to them so that they could see themselves in those same shoes. A lot of times she picked men as her plaintiffs so that the judges would understand the issues, and then she could expand that to women's cases later on.
Good job, Bonnie. Bonnie noted, and I don't know if it's McLeod, and she registered to vote. She's not an attorney, but she's on here today listening. She registered to vote for the very first time.
This is Stephanie Pokup out here in the Sixth Circuit. Thank you for including us, and thank you so much for the idea of setting up a women-in-law Zoom about Justice Ginsburg. And Judge Schreier, thank you so much for that very lovely and just elegant way of celebrating her life. When I heard that Justice Ginsburg died, my phone just blew up. So many women lawyers just saying, you know, just it felt like it did feel like a tidal wave. My mom, I was with my mom, she's in my pod, and we cried all weekend, and we couldn't even say why. we couldn't really enunciate why, but I think Judge Schreier, you just covered it. She was such an icon for equality, and it feels like a moment has passed us now, but it also does feel like a call to action. So thank you for giving us a chance to share a little time together about her.
Thanks, Stephanie. And I agree with you. It was, especially those first days was really hard. And I'm actually surprised I was crying today because I thought I'd gotten over it, but obviously not.
I guess a glass half full comment about the confirmation hearing. And it's hard to sometimes to get there, but got plenty of time out here in Gregory. But like never again, I think never again will there ever be a time when anybody hears that the nominee is a woman and thinks they won't be able to withstand a Senate hearing. And honestly, Judge, I did get a huge sense of empathy for what judges must go through having to listen to people basically restating their personal arguments and their philosophies over and over instead of actually questioning a witness. So, but like I think that day when people would even think, oh, it's a woman, this hearing will be hard, like that's just gone. So that's my helpful thought for the day.
Judge Schreier, how are you?
Hi, Julie.
Sorry about that. I just wanted to say that you did exactly what you said that, whose is that? Is that mine? Sorry. You did exactly what you said Justice Ginsburg said we were supposed to do. You put us in her shoes today. So thank you so much for doing that.
Thank you.
Judge Schreier, I wanted to thank you for your beautiful presentation. I'm proud to say my daughter-in-law just graduated from NYU Law School and just passed the Minnesota bars, so we're very happy. But Ruth Bader Ginsburg took time to come visit with her class in an intimate setting about 2 years ago, and she sat in a little chintz chair with a cup of tea, and my daughter-in-law, who was exposed to speakers from all over the world at NYU, the most powerful, important people in the world, said that that 1 hour spent with Ruth Bader Ginsburg was what inspired her the most at law school. So I wished I had had that opportunity, and thank you again for your speech today. Very much welcome.
She really was very giving with her time. I was on the planning committee for the circuit conference, and when we had invited her to come and speak, I think we all thought it was just a pipe dream, and she responded right away and was so excited about coming out to Omaha, and really very disappointed when the conference ended up being canceled because of COVID. But she was always one of the justices that attended every opportunity when we would invite Supreme Court justices to judge events. She was always there. She was just remarkable.
We do have a couple questions in the comments. Ms. Barbara, I don't know if it's Barbara. Yes, we will have the recording available. Judge Schreier, you did so well. People want the recording right now. Seth also says thank you and wants to ask you, what were your thoughts on the transition from Justice Ginsburg to the notorious RBG?
So she really became a pop icon, and it's, you know, through a lot of things that you wouldn't expect a Supreme Court justice to become an icon. whether it was her exercising or wearing the gilet or becoming notorious because of her positions. Really remarkable, I think. And she's not someone that, when I first met her, that you would have expected her to reach that level, because she is extremely reserved. She does not chit chat about the weather or about things that we normally would talk about. She was a very serious person that wanted to talk about substance. And if you weren't prepared to talk about that, your conversation was very limited. So to me, it's just remarkable that she became as liked and as famous as she was.
Can I make a comment? So, Judge, I was really struck when she passed away with the difference between her and Justice O'Connor. Because Justice O'Connor was the first on the Supreme Court, but she didn't have the impact on all of our lives that Justice Ginsburg did. And there are women and men and transgender that are pioneers because they were the first, or one of the first of a few. But there are many of those that don't turn around and offer a hand to those who are coming up behind. And that's what Justice Ginsburg did. She not only made the justices on the Supreme Court identify with her clients and imagine that they could be in their shoes, she made us imagine that we could be in her shoes. And Judge, I just want to say, in the role models between O'Connor and Ginsburg, you are definitely in the Ginsburg camp, because you're a pioneer here in South Dakota, the first female district court judge that we've ever had. And you always have your hand out trying to help up those who are coming up behind. And I just wanted to say thanks for this really great presentation about Justice Ginsburg. And thank you for emulating her here in our district. It's not just me. Lots of other people appreciate and acknowledge and understand the role that you've played. So thank you.
Thank you, Veronica. I think it's important for all of us to reach back and help others. I think especially as women, even though there are a lot more women practicing law now than there were when I first started, it's still hard. It's hard work. It's hard to balance family and life and practicing law. And we all need to just reach out and help each other.
Well, I agree, Judge, and I think most people on here, probably everybody agrees. And thank you, Judge Duffy, for your comments as well. Last chance here. I don't want to take up too much more of Judge Schreier's time. She may have to, what do you have to powder up before the next hearing? So a couple seconds here, and then I'm going to cut us all off. And thank God tomorrow is Friday, right? There are some good comments in here, Judge Schreier. I don't know if you've seen them. All right. Thank you so much for attending. Once again, this is put on by the Second Circuit Women in Law, but we have opened it up, and I think everybody who has been here at this time can see why. So lots of good stuff that we heard today. Thank you so much, Judge Schreier, for opening up about this to us. And no thank you for making me tear up, but it was awesome. But thank you so much, and thank you everybody for attending. Please reach out to me personally if you want a recording. I'll also post it if I can, and I'm not a tech person, on try to send it out on the listserv. But I'm at Gooseman, so you can find my contact information on the Gooseman website. Very easy to find. So thank you very much, and everybody have a good day and a good weekend, and thank you. Thank you, Judge Schreier.
Thank you.